Hello and welcome to Daily News Simplified, where we take up important articles of the day from the newspaper and discuss them in detail as per the demands of Civil Services exam. Articles covered today are displayed on your screen and their notes in PDF and Word format are provided in the description box down below. Without further ado, let us begin.
Starting off with the first article of the day, which appeared on page 1 of today's Hindu newspaper. In this article, the Patna High Court it dismissed all the petitions which were filed against the decision of Bihar government to conduct a caste-based survey. Now, upholding this action of the government to conduct a caste-based survey, the division bench of the Patna High Court it held that the decision was perfectly valid and it allowed the Bihar government to conduct such survey. Now, caste it is a salient feature of Indian society. Hence, it is important from GS paper 1 perspective. Further, in GS paper 2, the syllabus mentions mechanisms, laws, institutions and bodies which are constituted for the protection and betterment of vulnerable section, and backward classes are such vulnerable sections. Further, in the mains of the year 2020, a question appeared on whether the caste has it lost its relevance in understanding the multicultural Indian society. Further, caste-based reservation is covered under the Article 16 subsection 4 of the Indian Constitution. Hence, such policies and actions are also important from prelims perspective, which is apparent from this PYQ of the year 2023. Hence, in the scope of today's discussion, we will first cover about what is a caste-based census or a survey. Further, we will also discuss with the arguments that favors conduction of such surveys and arguments which are against. In the end, we will discuss a way forward as to what measures are further needed to make this exercise more inclusive and holistic. Hence, let us start off our today's discussion about understanding what is a caste-based survey. Now, what is a caste-based survey? Caste census or survey, it is a caste-wise tabulation of population which can be conducted in a census exercise. Now, enumeration of caste was last included in the Census of India dating back to the year of 1931. This practice it was stopped by the British in the 1941 census, and post-independence, the government of India it did not revive such practices. However, subsequent census in post-independent India, it publishes a separate data on scheduled castes and scheduled tribes. However, such census data does not include other castes. Now let us discuss why such enumeration of caste-based census was stopped in the first place. It was stopped because estimates on caste data are already available with the government of India. As reasonable estimates of broad social breakup of Indian population, it is already available through various government surveys. Now such data is available with the government through conduction of National Sample Survey Office data or National Family Health Survey data. Hence, the need for caste-based estimates were not felt. Further, there are operational difficulties in conduction of such surveys as well. As a full caste-based census, it will include a jati-wise breakup which would pose extreme difficulties. As currently, we do not have any official list of all castes in the country. And this would mean that an extensive post-census classification work will cause further delay in publication of census exercise. And this will create difficulties for all other activities that are associated with census exercise. Further, conduction of caste-based survey can promote identity politics, which may further lead to marginalization of developmental issues such as health or education. Further, conduction of such surveys may lead to rise in demand for higher quotas, and it will further pose a threat to the judicial imposed cap of 50% on reservations. Hence, such surveys were stopped in the first place. Now, due to demands of various sections of the society, some state governments have decided to conduct caste-based survey. For example, Bihar, Now, why is there a need for such caste-based survey? Let us discuss this in the next slide. Now, arguments which support the need for caste-based surveys include that the current data on castes, which are collected by NSSO and National Family Health Survey data, are based on survey-based estimates, which is unlike the census data. Because the census is actually the enumeration of every person in the country and it is not based on estimates. Further, census also generates data on educational level, occupation, household assets, and life expectancy of each group, and it enumerates at each level that is recognized by the Government of India. Further, there are common practices that some census data are released with a gap of 5 to 7 years after the census is completed. Hence, an enumeration of caste-based survey can be published even after the census data is generally published. Further, caste-based census is also important because it is necessary to understand people's socio-economic status, which are determined by caste and their subcaste. And such data, it will help in designing policies for affirmative action and redistributive justice. Further, the Supreme Court in Indra Sahni judgment, it highlighted that caste-based evidence it needs to be collected every 10 years or so in order to screen out the privileged caste from the benefits of reservation. And a caste-based survey is a need of the hour for evidence-based policy making. Further, over the last decade, we have witnessed some of the largest mobilizations which are based on caste, and it was done by the dominant sections of society, such as Jats, Patels, and Marathas, and they demanded reservations. However, these demands were not based on scientific evidences on the size or their relative level of deprivation. Hence, a caste-based survey will provide us with the data which will eventually help the government to evaluate such demands based on scientific data. And it will help the vulnerable section to legitimize their demands for reservation policies. Now that we have understood the need for caste-based survey, let us understand a way forward which will further help to utilize existing data to improve the condition of backward classes in the country. The first way forward is to understand the utility of already existing data, and it will eventually help in conduct of academic exercise which will help map social inequalities and social changes in the Indian society. Further, there is a need to read all existing data in a holistic manner, as linking and syncing of aggregated census data with other large datasets such as NSSO and National Family Health Survey data, it will help cover issues that the census exercise eventually do not. For example, maternal health of marginalized section women. Further, there is a need to undertake changes in the census exercise, as it will help employ methods that are precise, faster, and cost effective, and it will eventually lead to better coordination between different data sources. Additionally, there is a need for stock taking of previous exercises, as it will help us learn the changes that are necessary in conduction of census exercises. Further, there is a need to address concerns that are associated with census exercise, as there is a need to address the issue that are related to methodology, relevance of census exercise, dissemination of census data, transparency mechanism, and ensuring the privacy of such data. It needs to be taken seriously in order to make the exercise of census more effective. Hence, by utilizing the existing data on castes, reading all the different data sets holistically, inculcating changes in census exercise, stock taking the previous exercise, and addressing the concerns that are related to methodology, transparency, and privacy will enable the caste-based census to facilitate an effective policy work, and it will further help academy in order to map social inequalities and social changes with respect to Indian society. Hence, this was all for today's discussion on caste-based survey. Now, closely related with the discussion held in the previous article is the news on page 12 of today's Hindu newspaper. In this news, the article highlights that the Justice Rohini Commission, which was constituted for sub-categorization of other backward classes caste groups, it submitted its report to the Ministry of Social Justice and Empowerment. Now the government, it had formed the commission in the year of 2017, and this commission was headed by a former Delhi High Court Chief Justice, Justice G. Rohini. And the commission, it was asked to examine the extent to which the reservation and other benefits for the OBCs are concentrated among some dominant caste groups. And based on this mandate, the commission was then tasked with suggesting a breakdown of over 2600 castes which are there in central OBC list so that these benefits could be more equitably redistributed. Now, mechanisms, laws and institutions which are constituted for protection of betterment of vulnerable section is an important topic in GS paper 2. Further, issues related to marginalized sections that are scheduled caste are asked in UPSC mains exam, which is apparent from this PYQ of the year 2018. Further, in the previous year question in prelims of the year 2020, a question appeared on legal services authorities, which are constituted to protect members of marginalized sections of the society. Hence, this topic is important from exam's point of view. Hence, in the scope of our today's discussion, we will first discuss details regarding this commission as it was constituted under Article 340 of the Constitution. Further, we will discuss the genesis of the idea of sub-categorization, followed by the need for such categorization of OBCs in the country. Then, we will discuss the challenges that are associated in implementation of sub-categorization of OBCs before concluding this article with a suggestive way forward. Hence, let us start off our today's discussion about a commission on sub-categorization. Now, Article 340 of the Indian Constitution, it enables the President to appoint by order a commission which can investigate the conditions of socially and educationally backward classes of Indian society. And hence, Justice G. Rohini Commission was formed in the year of 2017, and it aimed to improve the sharing of benefits among the other backward classes communities in a more equitable manner. Now, this commission was given a mandate which was there to examine the extent of inequitable benefits of reservations among castes which constitute the central OBC list. And based on these, the commission was then mandated to work out a mechanism, criteria, norms, and parameters to undertake a scientific approach for sub-categorization of such classes. This idea of sub-categorization was first mentioned by First Backward Classes Commission report, which published in the year of 1955. And this report, it proposed sub-categorization of OBCs into backward and extremely backward communities. Further, the Mandal Commission report of the year 1979, it had a dissent note by a member called L.R. Nayak, and he proposed the sub-categorization of OBCs in intermediate and depressed backward classes categories. Further, in the year of 2015, the National Commission for Backward Classes, it proposed the division of OBCs into three categories. The first category was EBC Group A, where communities who face social, educational, and economic backwardness even within the OBCs are included. In the second category, called MBC Group V, it consisted of vocational groups who carry out with their traditional occupations. Further, the third category was backward classes Group C category, which will comprise of communities who are comparatively more forward with respect to these two categories. Hence, According to National Commission for Backward Classes, 11 states have subcategorized OBC for the purpose of reservation in state government owned institutions. Hence, the issue of subcategorization is an important area of discussion. Now you'll ask, why is there a need for such categorization of other backward classes communities? Let us find out in the next slide. Now, as we know that the benefits of reservation, it has reached only a limited section of the society, as there are about 2633 castes who are included in central OBC list of the union government. And out of these 2633 castes, around 1900 castes, they have not proportionally benefited from policies of reservations. And half of these 1900 castes, they have availed no benefits at all, while the rest half, they have cornered only about 3% share of benefits that accrue to this community out of 27% of reservation. Further, 25% of the benefits are cornered by 10 subcastes who are economically more dominant. Hence, we can say that the benefits of reservation policies for other backward classes are tilted towards economically stronger subsections among the OBCs, and hence there is an immediate need for subcategorization of OBCs, which will then include benefits for marginalized sections such as these 1900 castes. However, implementation of such subcategorization face certain challenges. What are these challenges? Let us understand in the next slide. Now, the first important challenge is that subcategorization, it is a politically sensitive issue, and subcategorization which go against this dominant section may further lead to agitation by some sections of the society. Further, the decision for subcategorization is based on the use of older estimates which may be unreliable in nature. As recommendations, they are based on population figures which were there in 1931 census and not on the more recent 2011 socio-economic census which was held by Government of India. And since the implementation of Mandal Commission report, more than 500 new castes have been added to central OBC list, whereas the 1931 census data, it did not have the population of these new additions. Further, the 1931 census, it also did not include the population data from princely states. However, these princely states, they were added to the Union of India, and hence the population currently, it also included the population and castes which were there in princely states. Further, there have been information availability issue with regards to social and educational status of other backward communities. As census exercise currently, it does not include education data and segregation of population based on other backward classes category. Further, subcategorization of OBC is also a difficult exercise for statistical reasons, as India has a large number of castes and they vary from state to state, and hence the data collection, it needs to be more comprehensive and robust in this regard. Now you will ask, what more can be done to ensure equitable benefits to such categories of population? Let us find out in the next slide. Now, as the article suggests that the subcategorization of OBCs, it needs to be based on relative benefits that accrue to various sections of OBCs, and these subcategorization should not only be based on the criteria of social backwardness, as this will help the deprived section to avail their fair share of benefits of the affirmative action policies. And the Commission, it has suggested the breaking up of caste groups into broad categories, with dominant castes who have access to more benefits currently, they will be getting a smaller share of the 27% reservation, while the historically crowded out groups, they will eventually get a larger share of the reservation pie. Hence, in this regard, there is a need to have a fixed quota system within the existing 27% quota for more than 1900 castes, and it might be in the range of 8 to 10%. Further, there is a need to revise the creamy layer ceiling, which is currently 8 lakhs per annum, as this limit is not currently up to date with the associated purchasing power of various sections of Indian economy. Hence, by improving sub-categorization in terms of relative benefits, having a fixed quota within 27% at the range of 8 to 10% for these communities, in addition to revising the creamy layer ceiling, will help equitable sharing of benefits among the relatively deprived section of other backward classes of the country. And hence, sub-categorization in this regard is very important. Therefore, this was all for today's discussion on sub-categorization of other backward classes. Now moving on to the third article of the day, which appeared on page 11 of today's Hindu newspaper. According to this article, the UAPA, that is the Unlawful Activities Prevention Act, it grants the state agencies an extensive power to deal with terrorism activities. However, this act, it also reduces the judicial oversight effectiveness, which then undermines the personal liberty of citizen of India. Now, the Unlawful Activities Prevention Act, it is designed to prevent terrorism activities in India. Hence, it is important from GS Paper 3 perspective, which deals with the role of non-state and state actors in creating challenges to internal security in the country. Further, this topic is also important from mains perspective, which is apparent from this PYQ of the year 2019, which asked us directly about recent amendment of the government with relation to Unlawful Activities Prevention Act. Further, such acts are also important from prelims perspective, which can be seen from this prelims PYQ of the year 2023 on Prevention of Terrorism Act of the year 2002. Hence, in the scope of today's discussion, we will first take a brief overview about what is a UAPA Act. Then, we will discuss its significance as to how this act has proven effective in dealing with terrorism cases in the country. After this, we will also cover the challenges that are associated with implementation of this act, particularly with respect to the wide discretion it provides the state agencies. And after that, we will conclude today's discussion on highlighting the need for balance in maintaining the state security and ensuring the constitutional right to public in general. Hence, let us start off our today's discussion by taking a brief overview about what is an Unlawful Activities Prevention Act. Now, the Unlawful Activities Prevention Act of the year 1967, it was enacted to provide for a more effective prevention of certain unlawful activities, which may be of individuals or of associations. And it also helps deal with terrorism activities and related matters. This act, it defines what is an unlawful activity, which according to this act means any action that is taken by an individual or association that leads to secession of a part of a country, or it questions the sovereignty of India, or disrupts the territorial integrity of India. Further, under this act, the central government, it can declare a person or an organization as a terrorist organization if that organization, it commits or participates in acts of terrorism, prepares for terrorism, promotes terrorism, or is otherwise involved in terrorist activities. This act, it gives power to the central government to impose an all India ban on associations which are declared unlawful. Further, this act also provides for an appeal mechanism under a tribunal to hear or review the decisions of central government. The jurisdiction of this act, it extends to both Indian and foreign nationals. Also, the act holds offenders accountable in the same manner even if the crime is committed on foreign lands, that means outside the domestic jurisdiction of Indian geography. Under this act, the cases related to terrorism can be dealt with both state police as well as the National Investigation Agency or the NIA. Now, the 2019 amendment was the most recent amendment of this act. As per the amendment, the government has now become empowered to designate an individual as a terrorist, whereas earlier only an organization could be designated as a terrorist organization. Further, if the investigation is conducted by an officer of the National Investigation Agency, the approval of Director General of NIA can be required for seizure of property which is connected to terrorism, whereas earlier only the approval of State DGP was required. Further, the Act also empowers the officers of NIA, who can be of rank of inspector or above, to investigate cases which are related to terrorism. Additionally, this Act also amends the schedule of the Act, and it adds the International Convention for Suppression of Acts of Nuclear Terrorism of the year 2005 in it. Now, after we have taken a brief overview of what is an Unlawful Activities Prevention Act, let us discuss its significance in the next slide. Now, this act, it helps uproot terrorism from India. As terrorists and insurgents, they continue to receive material support and funds which are main drivers of terrorism, and these funds are sought from several sources in India. For example, since 2001, 8,500 citizens of India, they have died at the hands of terrorists, and this act tries to overcome this hurdle. Further, this act also brings focus on individuals. As before, not designating an individual as terrorist, it would give them an opportunity to circumvent the laws, as they would simply be required to gather under a different name, and it will enable them to keep up with their terrorist activities. Hence, in this context, the 2019 amendment, it became important in controlling the menace of lone wolf attacks, as these lone wolf attacks, they are carried by members who mainly do not belong to any terrorist organization. Further, this act also quickens the mechanism of justice delivery, as officers who are rank of inspectors, they are now become empowered to investigate the cases under the UAPA Act. As inspector rank officers have now acquired the sufficient proficiency to investigate UPA related case, it would mean that the justice delivery process will be further quickened. Further, this act also reduces the delay which were associated with attaching the proceeds of terrorist activities. As this act, it allows the seizure of property which are connected to terrorism without having the need to take approval from state police DGP. And this can be the case when an investigation is conducted by the National Investigating Agency. Now, after we have discussed the significance of UAPA Act, let us take a look at challenges that the UAPA Act might face. The first challenge, it relates to vague and unclear definitions provided in the Act. As the Act currently, it does not define what is a terrorism, and the definition of unlawful activity is such that it covers almost every kind of violent act, be it political or non-political in nature. Further, this act also provides excessive discretionary powers to state agencies, as there is no objective criteria which has been laid for categorization of individual as a terrorist, and the government has been provided with an unfettered power to designate anyone as a terrorist. Additionally, the Unlawful Activities Act have a negative impact on fundamental rights, such as rights which are covered under Article 14, 19 or 21. As the UAPA Act, it does not provide any opportunity to the individual who is termed as a terrorist to justify his case before the arrest could take place. Also, the information which declares a person as a terrorist can be withheld from that person for a period of 6 months. And those who are arrested under the Act can be imprisoned for 180 days without having the need for the charge sheet to be filed. Also, this act suffers from low conviction rates, as out of 5,922 persons who have been arrested under the act between the year of 2016 and 19, only 2.2% have resulted into conviction by court of law. Further, there has been an issue which are associated with the appeal process of under the act, as it rests currently with the executive. The Act, it provides for an appeal mechanism, but the government itself will set up a 3-member committee. And out of these 3-member committee, 2 of them are serving bureaucrats. And hence, this affects the separation of power that is envisaged in the Constitution of India. As India suffers from the menace of terrorism, there is a need for a stringent law to fight terrorism activities. However, this must be done by ensuring the balance between state security on one hand and human rights and constitutional values on the other hand. Therefore, this act is crucial for expediting prosecution in terror cases. However, there is a need for a due process of law which should be followed by state agencies who are involved under this act at every stage. Also, there is an important role of judiciary which can help check the misuse of such laws. This was all for today's discussion on Unlawful Activities Prevention Act of the year 1967. Now moving on to the last article of the day that appeared in page 9 of today's Hindu newspaper. As per this article, in the last few years, the climate justice activists, they have been campaigning to the world's economically developed countries in order to raise investments in climate adaptation and mitigation, which includes paying for other countries' abilities to deal with the effects of climate change. Countries in sub-Saharan Africa, Latin America, and South Asia, they have historically contributed the least to the process of global warming. Yet, these countries, they are bearing the bigger brunt of climate disasters, both in form of extreme natural phenomena and dead distress. Hence, there is a need to have a robust system of climate financing. Now, climate finance is important from GS Paper 3 perspective, which includes environment and biodiversity. Further, the mechanisms to limit the effects of climate change is also important from mains perspective, which is apparent from this PYQ of the year 2021 on Conference of Parties to the UNFCCC. Further, the issue of climate finance also finds itself in the prelims of the year 2023, in which a question appeared on carbon markets. And hence, the issue of climate finance is important from exams point of view. Now, climate finance, it refers to local, national or transnational financing which may be drawn from public, private or alternative sources of financing. And these finance, it seeks to support activities which are related to mitigation, that is reducing the greenhouse gas emissions, and adaptation, which means adapting to adverse effects of climate change. And hence, the climate finance, it seeks to address the issue of climate change. Now, climate financing, it is essential to help the world reach the target to limit the increase of global warming to 1.5 degrees centigrades. And the mechanisms such as United Nations Framework for Convention on Climate Change and its associated Kyoto Protocol, Paris Agreement, they call for financial assistance from parties who have more financial resources, and these resources should be transferred to less endowed and more vulnerable countries. In this regard, we will first discuss the mechanisms that are available for climate financing, in addition to challenges that these mechanisms faces. Towards the end, we will also discuss a way forward that can help improve the climate's financing situation around the globe. Hence, let us start off our today's discussion with mechanisms of climate financing. Now, currently, there are various mechanisms available for climate financing. First, let us discuss the mechanisms which are available under United Nations Framework Convention on Climate Change. The first mechanism is that of Global Environment Facility or GEF, which serves as an operating entity for financial mechanism since the convention entry into force from the year 1994, and it manages two funds. The first is Special Climate Change Fund or SCCF. It was established in the year of 2001 in order to finance projects which are related to adaptation, technology transfer, and capacity building. And it seeks to economic diversification of energy, transport, industry, agriculture, forestry, and waste management. The second fund under GEF is Least Developed Countries Fund or LDCF, which was established to support a work program to assist least developed countries in order to carry out the preparation and implementation of national adaptation program of actions. Secondly, there is an adaptation fund which was established in the year of 2001 to finance concrete adaptation projects and programs in developing countries who are parties to Kyoto Protocol and that are particularly vulnerable to adverse effects of climate change. The latest under this regard is Green Climate Fund or GCF, which was established in the year of 2010, and developed countries they have pledged $100 billion per year by 2020 through this fund, which was done in support of developing countries in enabling them to raise and realize their nationally determined contribution ambitions, which may be done towards low emission and climate resilient pathways. There are other United Nations backed funds as well. The first of which is Clean Technology Fund or CTF, which aims at empowering transformation in developing countries by providing them with resources to scale up low carbon technologies. The second is Climate Investment Fund or CIF, which aims to accelerate climate action by empowering transformation in clean technology, energy access, climate resilience, and sustainable forest in developing and middle income countries. The third is United Nations Reducing Emission from Deforestation and Forest Degradation, also known as RED Initiative, which aims to protect forests which are a preeminent nature-based solution for climate emergency. The latest development in this regard comes from Net Zero Asset Owner Alliance, which has 29 members and it includes pension funds, insurance companies, sovereign wealth funds, and this alliance it is working on methodologies to align portfolios with net zero Paris targets. Now, after we have discussed transnational initiatives, let us discuss few national and local sources of raising finance, such as initiative which was taken by Government of India. For example, there is a National Adaptation Fund for Climate Change, also known as NAFCC, which is a central sector scheme, and it was set up in the year of 2015 and 2016, and it was done to support concrete adaptation activities which mitigate the adverse effects of climate change. Additionally, there are carbon pricing instruments as well, which include a carbon market approach where an emissions trading scheme is implemented and carbon credits are bought and sold based on market price per ton of carbon emissions. Also, there is a carbon emissions tax approach, which can be in form of fossil fuel tax or removal of fossil fuel subsidies, etc. Now, despite this elaborate mechanisms for climate financing, it has been seen that the world it is unable to bring the target of global warming under the limit of 1.5 degrees centigrade, as global average emission per capita is currently the double the target of intended 2.3 tons per capita emission, and it has stayed at the levels of 4.7 tons since the year of 2010, and hence This highlights the inability of existing climate financing in limiting the impacts of climate change. What are the challenges in this regard? Let us discuss in the next slide. Now, what are the challenges that are associated in mobilizing the climate finances? The first challenge is that the amount provided by international organizations are insufficient. While climate finance in the year of 2017 and 18, it crossed the mark of about $0.5 trillion. However, according to IPCC report, an estimated investment required was between 1.6 to 3.8 trillion dollars per annum, and hence the provided amount is insufficient. Further, there has been stress which was due to COVID-19 pandemic, as the disruptions which was caused by pandemic such as need for emergency services coupled with reduction in tax revenues, it led to diversion of funding away from climate resilience project and renewable energy projects. Further, there have been a lack of investment ready projects and most projects that require further assessment regarding scale of return in terms of contribution in climate change or adaptation. Further, there has been gaps in the system of present knowledge about climate financing. These include issues such as lack of common definitions for central concepts related to climate financing or financial accounting rules. And it is further aided by limited awareness by national policy makers on financing mechanisms that already exist. Further, there has been an issue which are associated with inadequate funds to small countries. As least developed countries and small island nations, they launched a Warsaw International Mechanism in the year of 2013. And this mechanism was there to provide developing countries with finance, technology, and capacity building in order to help victims of climate change recover after extreme weather events. However, no considerable progress has been made in order to solidify the financial commitments of developed nations. Also, the developing countries they have been facing obstacles in accessing of international climate finance. For instance, India, 85% of climate financing is sourced from domestic sources. With private players such as commercial banks and corporations, they account for two-thirds of such funds. And this can be attributed to lack of efficient delivery channels and low awareness among policy makers. Additionally, as today's article highlights, there has been gaps in funds approved and funds that are disbursed. As since 2003, for example, about $3.3 billion were approved for South Asia and only $1.3 billion have been disbursed. And most regions in general, they have received only 40% of approved funding which are meant for that reason on average. Hence, there is a need for sufficient improvement in the situation of climate financing across the globe. Now, after we have discussed the challenges, let us take a look at way forward on what should be taken in order to improve the climate financing mechanisms around the world. Now, the governments they should introduce carbon pricing mechanisms, climate data systems, and criteria for assessing capital investments in green project, and it will help governments prioritize the climate smart investment options. Further, there is a need to enhance capital investment planning which are undertaken by local governments by integrating carbon pricing and other climate smart metrics into their decision making. Also important is the role of multilateral investment banks and developmental financial institutions, which needs to take an urgent measures in order to align their portfolios with Paris Agreement. Also, there should be an incentive structure and mechanisms such as tax rebates, which are required to promote private sector investments in both mitigation and adaptation activities in developing countries. Additionally, there is an immediate need to standardize the definition of climate finance, as developmental finance institutions they can promote best practices in order to track and report climate finance at project levels by developing harmonized definitions, taxonomies, and accounting methods. Also, there's a need to balance investments in climate adaptation and climate mitigation, as based on studies assessing the impacts of adaptation and mitigation and assessing the return on investment, there's a need to holistically address the issue of climate change. Also, there's an imperative for developing additional funding mechanisms which are related to loss and damage, as efforts can be facilitated by establishing other funds that can pool both private and public investments for developed nations and global insurance mechanisms in order to compensate for loss and damage. Hence, to conclude, the Indian Ministry of Environment and Climate Change, it estimates that the country it would require about $2.5 trillion between 2015 and 2030 for effective climate actions. Hence, it is essential to scale up the efforts of international, national, and local levels in order to mobilize and effectively utilize the climate finance deal, which can help deal with ongoing and upcoming effects of climate change. Hence, this was all for today's discussion on climate financing.